The word causation simply refers to the phenomenon in which something makes something else happen. Causation plays a role throughout public and private law, but it looms especially large in criminal law and the civil law of torts, or wrongful harms. Causation is almost always a necessary element of a tort. If you've suffered a misfortune of some kind and you want to hold someone else legally responsible for it in a lawsuit, you're going to have to talk about what caused your misfortune. The great 18th century German philosopher Immanuel Kant calls causation one of the basic categories of the understanding. We make use of causal notions constantly in everyday life, whenever we employ transitive verbs such as cause, damage, create, change, affect, or eliminate. You might assume that you already know everything there is to know about causation, but actually causation is a tremendously difficult and confusing subject. Our topic here is legal causation, the concept or concepts of causation that figure in legal reasoning, especially in attributions of legal responsibility. Lawyers distinguish between cause in fact and approximate cause. An event or condition constitutes the legal cause of an effect, if and only if it's both a cause in fact and approximate cause. I'll discuss each of these ideas in turn, beginning with cause in fact. A tennis ball knocks a wine glass to the floor, where it shatters. The ball is a cause in fact of the glass breaking. More precisely, you might say that the ball striking the glass at 10 kilometers per hour is a cause in fact. Or even the ball striking the glass at a 45-degree angle at 10 kilometers per hour. There are actually many other accurate ways to describe the event. Notice I said a cause in fact, not the cause in fact. This is because any given event has many causes in fact, maybe even an infinite number. There are several philosophical theories of cause in fact, but we only have time to discuss one of them. It's called the but-for theory. But-for theory classifies only necessary conditions as causes in fact. The theory states a prior event C is a cause in fact of a later event E, if and only if it's the case that if C had not occurred, then E would not have occurred either. Let's say Sophia threw the ball that hit the wine glass. Had she not done so, then the wine glass wouldn't have broken. So her throwing the ball is also a cause in fact of the glass breaking. Cause in fact is an indispensable concept, but it can't be the whole story about legal causation. Each effect has too many causes in fact to count. Recall Sophia throwing the tennis ball that hits the wine glass. If she'd stayed in bed today, then she wouldn't have thrown the ball, so her getting out of bed is also a cause in fact of the broken glass. So is the fact that Sophia's parents conceived her, that their parents conceived them, and so on. But we wouldn't ordinarily think of Sophia's great-grandmother as a cause of the broken wine glass. Thus far, I've only considered events as causes in fact. If we widen our gaze to consider other conditions, then the universe of causes in fact grows still larger. Take the fact that no one kidnapped Sophia this morning. This is a condition, a state of affairs, but it's not an event. It's the absence of an event. If such conditions can also be causes in fact, then Sophia's non-kidnapping is a cause in fact of the glass breaking, since she wouldn't have thrown the ball had she been kidnapped. The same goes for the fact that no one moved the glass across the room before it was struck. The question whether non-events can be causes is philosophically controversial. But whether or not we consider non-event conditions like this to be causes in fact, the basic problem remains. There are too many causes in fact, stretching back in time, for the law to take notice of them all. The law is only interested in a tiny subset of the causes in fact of an effect. The important subset are called proximate causes. Causes in fact that are not proximate are called remote causes. The law has to define proximate causes by placing limitations on the set of causes in fact. One limitation is that only legal persons can be proximate causes. That means human beings or institutions that are granted legal personhood. Tornadoes, stampeding stallions, and runaway trains can wreak havoc, but they're not legal causes, whatever they do. The other limitations are more complicated. You were assigned an excerpt of the most influential treatment of legal causation, the 1959 book Causation in the Law by H.L.A. Hart and Tony Honoré. Hart and Honoré claim that C is not a proximate cause of E if a certain type of subsequent event S occurs. Suppose a man named Abe spills gasoline in the forest. A little later another guy named Ben drops a lit cigarette on the same spot on the ground. Ben didn't see Abe spill the gasoline. The cigarette would have gone out harmlessly without the gasoline, and the gasoline would have dissipated into the air without the cigarette. But together, they start a terrible forest fire. Abe and Ben are both causes in fact of the fire, but only Ben is a proximate cause. Ben's dropping of the cigarette is a subsequent voluntary intervention. Such events break the causal chain initiated by Abe, and begin a new causal chain starting with Ben. Other types of subsequent events can also break the causal chain, according to Hart-and-Honoré's theory. Carol pushes Deborah off the sidewalk and into the street. A second later, an overhead scaffold collapses. Falling debris injures Deborah, who would have been safe on the sidewalk. This is a coincidence. Carol is a cause in fact of Deborah's injury, but not a proximate cause. Paraphrasing Hart-and-Honoré, we can define a coincidence as a conjunction of two or more events, close to each other in space and time, where the following conditions are satisfied. The two events happening close to one another in space and time is very unlikely, and the conjunction makes a causal contribution to the effect, and the two events occur independently, and no one's arranged for the events to happen together, and neither event constitutes a pre-existing condition. Let's apply these conditions to our hypothetical. The two events are Deborah stumbling into the street and the scaffold collapsing. First, it's very unlikely that two such events would occur close to one another in space and time. By contrast, there's no coincidence if Carol pushes Deborah into a busy street and Deborah's struck by a car. Cars are common on busy streets. Secondly, the conjunction is a cause in fact of Deborah's injury. Thirdly, the first event did not make the second event more likely. By contrast, if Carol shoves Deborah into a mechanical lever that releases the scaffold, then the events are not independent, and Carol is a proximate cause of Deborah's injury. In the original scenario, however, the events are independent. Fourthly, no one arranged for the events to occur together. What if the nefarious Carol had known that the scaffold was about to collapse and pushed Deborah in order to put her in the path of the debris? In that case, Carol would be a proximate cause of Deborah's injury. Finally, neither event constitutes a pre-existing condition. For the sake of contrast, let's remove the scaffold from the scene and imagine that Deborah has a weak heart and is easily frightened. She's terrified at being pushed into the street and goes into cardiac arrest as a result. Deborah's medical history and mental constitution are pre-existing conditions. Although Carol had no idea, she is a proximate cause of Deborah's heart attack. Whether she's liable under law is a further question. Many writers have followed Hart-and-Honoré's theory of proximate cause, but there are many difficult questions to be answered. The criteria are challenged as too vague. What does very unlikely mean? What constitutes a pre-existing condition as opposed to an event? What makes an intervention voluntary? To critics, these don't even look like questions about matters of fact. The whole idea that there are facts about proximate causation appears naive to them. Instead of defining proximate causes as though these terms had precise meanings, some theorists think we should simply ask whether it makes good sense to hold someone liable under various circumstances as a matter of good public policy. Critics also question whether Hart-and-Honoré's theory is fair. Someone who's momentarily careless and unlucky can find herself the proximate cause of an extremely costly accident, like the Great Chicago Fire of 1871 that started accidentally in a barn. The pre-existing condition criterion creates similar worries. Recall the scenario where Deborah has a heart attack. Although the criminal law should certainly find Carol guilty of misdemeanor assault for shoving Deborah, some consider it unjust to hold her accountable for Deborah's unexpected cardiac arrest. Hart-and-Honoré's theory is not the only way to understand proximate cause. Another way uses the notion of probability. The idea is that a cause in fact is a proximate cause of an effect, if and only if events of that type significantly increase the objective probability of effects of the type that occurs. If Carol pushes Deborah into the street where a car hits Deborah, then Carol is a proximate cause because one could have known in advance that pushing Deborah significantly increases the risk of that type of accident. Being struck by a car in the middle of a busy street is said to be within the risk of being pushed into a busy street. But if Carol pushes Deborah into the street and the scaffold collapses on Deborah, then Carol is not a proximate cause because one would not have thought in advance that pushing Deborah would significantly increase the risk of that type of accident. Being struck by a collapsing scaffold is not within the risk of being pushed into a busy street. This theory has strong support in both criminal and civil law. Finally, some commentators claim that causal chains gradually weaken over space and time. They insist that an event should not be seen as a proximate cause of a much later effect or a very distant effect, even if all the other criteria of proximate causation are fulfilled. Their objection is illustrated with the famous case of Palsgraf v. Long Island Railroad Company. Mrs. Palsgraf was standing on a railroad platform as a train pulled away. A passenger carrying a package ran ahead to catch the train as it left. He nearly fell, so 2 railroad employees attempted to help him, giving him a final push from behind to get him onto the train. This push caused the passenger to drop his package. Unbeknownst to the employees, the package contained fireworks that exploded on impact. As a result of the explosion, some scales at the other end of the platform fell and struck Mrs. Palsgraf. She sued the railroad, which is responsible for injuries tortiously caused by its employees in the course of their employment. A jury found in favor of the plaintiff, Mrs. Palsgraf. The verdict was affirmed on appeal, but reversed by the High Court of New York in an opinion authored by Justice Benjamin Cardozo. After this lecture, you can watch a whimsical reenactment of the case using Lego blocks. If we accept Hardin Honoré's theory of proximate causation, then it would seem that the railroad employees' actions are the proximate cause of plaintiff's injuries. Their pushing the passenger is a but-for cause of the package dropping, which is a but-for cause of the explosion, which is a but-for cause of the scales falling, which is a but-for cause of Mrs. Palsgraf's injuries. There's no subsequent voluntary intervention or coincidence. You might think it's a coincidence that the package had fireworks in it, but that's not so according to Hardin Honoré. The existence of the fireworks is not an event, but a condition that existed prior to the pushing of the passenger. Of course, the whole thing is an extraordinary piece of bad luck, but that doesn't matter for the purpose of proximate causation. Palsgraf challenges Hardin Honoré in 2 ways. First, if you believe that the railroad should not, as a matter of justice, be held liable, then Hardin Honoré have to explain to you how their theory would not in fact impose liability. More importantly, from a lawyer's perspective, the High Court of New York does not appear to have accepted Hardin Honoré's theory of proximate causation. Instead, Justice Cardozo holds that Mrs. Palsgraf's injuries did not fall within the risk of the railroad employee's action, which suggests a different theory of legal causation.